Hey everyone, sorry we're late. Omar kept talking about mukbang and how much he liked it.
I was not. I was terrified that you brought it up. It's like, what are you even talking about?
I'm going to turn my camera off for the first part of the stream so I can eat without people enjoying it. So that's how that came up. But just for proof of life, I will bring my face back momentarily. But I'm going to turn it off for now. So I just saw that you were talking about the motion. You went through it. I went through it earlier, and then Elsie joined in a little bit. Speaking of which, I was supposed to text Elsie. Let me do that. But we went over it, and I thought, so what I'm confused about, obviously for me, who has no experience with this, is like, what is the standard for what you're supposed to provide? Because to me, it sounded like they did not do a very good job of that, but I'm not a legal analyst. You know what I mean? So
those billing motions are harder than you think, because you write the motion and then it's always subject to attack, and they attack wherever they think there's some kind of a discrepancy or whatever. Hey, you billed for this, but it's not properly labeled. Or what was it, like something like 83 different hourly billers, and it was heavily redacted because of privilege and things. And that's the thing. So what happens is you have like your internal billing, and then that has all of the privilege stuff and like correctly labels different things. But the thing that you give to the court and the thing you give to opposing counsel is like redacted, or so it won't have the accurate descriptions. Okay. And so rather than go back and forth in that, you could do a lot of things. You could try to do, I'm going to depose you to see what's in the thing or view the thing in camera. You could do all of that, or just make your freaking arguments. Because the bottom line is the judge is not born yesterday. It's not his first billing motion. He knows that he's going to get redacted billing descriptions or whatnot. But yeah, this is the game. It's they are asking for $8 million, and the Wayfarer parties are telling you why the billing isn't worth shit. Or is not worth $8 million.
I noticed they mentioned a different case of Wilkie's in here, where a Wilkie got like 1% of what they were asking for. Or not 1% even. I think it was more than that, but it was less than 5% of what they were asking for. Do you think that makes a difference?
Say it again?
Does that make a difference? Like, how impactful is that?
It's just impactful. Well, here's the thing. It's their general premise, the Wayfarer premise, is that we don't have to apportion which portion of the billing was attributed to defamation offense, because 47.1 doesn't make us. It specifically says the litigation, or in the litigation, which necessarily it should be interpreted as comprehensive to the entire litigation, in spite of the, as the Wayfarer parties pointed out, the antecedent sentence defense of the defamation is what they mean by the litigation. Yeah. And so the question then becomes, if they're going to say that, then the burden's on them that you have to, number one, if you get over that issue, the next issue is we don't have to portion it because the services that were provided were so intertwined, it's impossible to separate them. Like if I'm doing discovery on their entire complaint, it's necessarily going to have these 8 other causes of action. And by nature of us requesting discovery, responding to discovery, or doing whatever, all of that included necessarily the defamation case. So I can't tell you what was solely and exclusively only for the defamation case or the defamation defense, because it all went together. Like we didn't do anything exclusive to the defamation because we couldn't. That would have been malpractice, and it would have inexplicably raised the hourly rates to an absurd rate. And so therefore, everything that we did until the complaint was dismissed was for the defense of the defamation. And I don't have to portion any of this for you because you can kiss my ass. That's what the Wayfarer party, or not the Wayfarer, that's what the Lively parties are saying. Yep. Now Wayfarer is saying, look, not impressed, because first of all, you didn't even try. You came up with this ridiculous premise, 47.1 for comprehensive litigation, not just defense of the defamation. And you and I both know how to read. That's not what it says, and you know better, and your argument is frivolous. Number 2, you can apportion it. You just fail to do so. I can't help it if you don't know how to apportion things properly. Maybe you should get better billing standards. But because of that, I don't think that you should get billed for any of that. My logical conclusion or prediction was, if I'm Judge Lyman, like, I'm not dealing with this shit. If you're not going to apportion it for me, I'm just going to divide it by 9. And that was it. So
Michelle says, what does the New York Times ask for defamation? They asked for $180,000.
Yeah.
But I think so. Some of the causes of action against Lively were obviously not applying to the New York Times, and they're trying to argue, I think, that those causes of action should be included in these sort of fees and damages. Oh, Stuart's here. What's up, man?
Stuart.
I haven't seen you forever.
In like a year, it feels like.
Are you in a helicopter in your picture? That's crazy. I guess he's been having fun without us.
A pilot? Is he a pilot?
How's it going, man?
Because that looks like he's a pilot.
Maybe he is a pilot.
Wait, can't see.
Stuart, did you quit being a lawyer to become a pilot? If so, I think you're cool. All right. Anyways, we were just talking about Stuart and Keith the last time we did a stream together because we were just like, where did they go?
Whatever happened to those guys?
Yeah. But it's good to see.
Reminiscing how we were on their show, and then I don't know, I opined that you might have scared them off because.
Me? No, you totally scared him off. It was your
definitely
fault.
me.
Totally. Okay, let's see.
By the way, my idea of how you apportion, or my solution to the apportionment, Judge Lyman could do whatever he wants. He could cut it in half. He could cut it into a third. He could do whatever he thinks is right. My only point is, it sucks that they didn't make an attempt at apportionment, or maybe it doesn't. Maybe that's the strategy. It's like, look, if we just make the argument we don't have to apportion, maybe we just get the whole thing, or at least a substantial amount. Maybe he reduces it. He's definitely going to reduce it, but maybe he only reduces it by half. In my simplistic way of thinking about it is strictly mine. It's not Judge Lyman's. It's not in any way what's actually going to happen, or it might. I don't know. I guess we're going to have to wait and see.
Stuart says he is a pilot.
He would be a pilot. He's probably also rated like over 2,000 on chess.com. Every time I play chess on chess.com.
I bet he drives boats, like big boats. You know what I mean?
Yeah. I don't know. He doesn't look like a boat
busy
guy.
for you guys.
Stuart looks more like he's a mountains guy. I don't think he likes the water unless it's like on a lake.
So some of these line items that I saw in their spreadsheets, which weren't like individually addressed because who can do that in 10 pages, that I thought were kind of insane, were like some of the social media stuff, the monitoring and all that they were doing, where she's trying to say that they should pay her fees on that, her attorney's fees on that. And I was like, okay, is this like a GoFundMe for Ezra Hudson, or what are we looking at here? Because I don't understand how you can relate that back to an already dismissed defamation claim. But maybe there's something I'm not seeing here. So
I'm sorry, I completely zoned out when you were talking. If you asked me a question, I missed it.
So some of the the stuff they were asking for money for was like they were asking for social media monitoring and like the social media subpoenas and stuff like that. I'm like, that has nothing to do with.
Well, I think the most absurd example of that is they were literally researching the ramifications of Blake Lively's exposure to perjury related to the California CRD complaint. And they dropped that in the bill. And the Wayfarer party cited that. I was like, come on, man. I mean, that's a little bit ridiculous. Your exposure to perjury. We didn't tell you to perjure yourself.
No.
Why are we
my thought was, and I've heard other people talk about this, was I guess they're trying to ask for fees related to them researching like what she would have to say to defend herself against them saying she perjured herself. I don't know if that really matters, but that's the only thing I could think of, was like if they're saying like they're accusing her of perjuring herself, we have to defend her against that accusation.
Hey, Lauren, hold the fort for like 1 minute. I'll be right back. Yeah.
Oh, this is not going to go well. What's our wine for tonight? I don't know. I'm not drinking wine. I'm, old. Less old than Omar, but I'm old and tired. So it's different. So he says, check out Exhibit 13. Wilkie had a $500,000 fees claim reduced to $10,000. Yeah. So that was the one that we were talking about, where it's like a really small percentage of the ask was granted. So that's what I know Omar said, I heard him say he thinks 1.5 to 2 million is what's going to be the end result here. I'm a little more optimistic. I think it's going to be more like 500,000. But I have zero experience as an attorney, as you guys know, and I have zero experience following a case like this. But I do think that it's going to be more like 500,000. I hope it's less than $1 million, but I can never say for sure. Who knows? Judge Lyman is, I know he's not a fan favorite. Personally, observing him and how he works in his courtroom, pleasantly surprised with how things have turned out after the hearings that I've witnessed. So I don't know. I think it'd be more like 500,000, but that is just my kind of blind guess. Somebody's asking, hold on, Lauren, we're playing the game. Why aren't you on camera? We need an answer. Well, I'm right here. I'll bring the camera back up, but I got to finish eating. So I like got ready to make dinner, and I started to set up everything, and I was like, I don't have time, so I had to make this microwave mac and cheese that took like 13 minutes. All right, anyways. Stuart says it'll be over 7 figures. Okay. So we have the two lawyers, Omar and Stuart, think it will be over 7 figures. And then you have me, who has 0 attorney experience, telling you it will not be. So you guys take a decide what you think. I will tell you, I've never been wrong before because I've never guessed anything like this before. So
you're wrong like most of the time. You know what? But you did say you did drop like a really like nice nugget of knowledge that I didn't expect from you the last live stream you did, but it's because you got it directly from the Wayfarer attorney, from Fritz.
Yeah,
you said it's like, oh, well, that makes all the sense in the world. I'm gonna really stop talking about the settlement because that makes all the sense in the world.
Yeah, Kevin.
And then come find out that was Kevin Fritz's. It wasn't yours.
No, so Kevin's a cool dude, nice guy, really smart. Almost all of our conversation was a public conversation. So like, I know some people, like I have some creepy people who like follow and listen to everything I do, just waiting to like catch me in a smear campaign to where I'm like, you have no life. Like I'm just saying my opinion. I don't need to be a part of a smear campaign. But like some creepy people listened to that and were like writing on Reddit about how Kevin and I have secret conversations. And I was like, you can literally listen to it on my YouTube channel where he says that. Like, it's not a secret. We don't text and braid each other's hair. Like, it's not a thing. But yeah.
What varietal are you drinking tonight? I don't know. What is this? What kind of wine is this? It's generic white. How about that? What's it called? No, don't go check. I have a wine subscription. And I've had it for like a couple of years, and I used to be like, oh, what's all the tasting points in the wine? And it's like rated this or whatever. This is from this section of the world. I never give a shit anymore. And I
can never remember if I'm supposed to use your wife's name or not when I'm talking to you about her on the YouTube. So like,
you could say
I've decided no matter what she thinks about that, even if she's okay with it, I'm going to start calling her by a different name. So I think your wife's name is Hilda.
Hilda.
And, yeah, I will be referring to her as such.
Oh boy.
Yeah.
we were reminiscing last night about the first time we met, and it was quite the conversation, to say the least.
Oh, I heard that story. You guys told it to me.
Did we tell you that story? I don't think we told you that story.
I'm pretty sure you did, dude.
Well, I said, hey, we're here to talk about Blake. All right.
I know. I was thinking about that. I was like, you guys got married after that? Oh no, maybe that was a different date. I'm not sure, but I remember some stories. Let's put it that way.
Well, I just told her that.
I'm with your wife on this one. We're here to talk about Blake. Shut up, Omar.
Yeah. Well, stop getting me in trouble. How about that?
No.
Okay. All right. So look, the bottom line with this is, here's what I think it's going to be when I think it's going to be.
Yeah. Okay.
I said like $1.5 to $2.5 million. That's my prediction. It's a safe prediction. My real prediction is under 2 million, but more than 1.5, somewhere in there, because there's 2 buckets. Like there's 2 buckets of fees. Like the one is purely defensive work, and that's the one where you have the hourly rates of $21.87 or whatever. And there's a case in there for a reduction of 30%. And so they, in pure defensive work, had, I think it was, what was it, like 2.2 million? That was bucket 1. There was bucket 2 that was an additional $5.2 million that they said was so inextricably entwined that we can't apportion this, and we're just going to ask for it because there's no way to separate it from the defensive work. And that's where I'm going to call bullshit on that. Now, there's a couple ways to handle it. The uber conservative way were to just be like, look, I'm not giving you 5.2, but maybe I'll give you 2.6, right? And you add 2.6 to 70% of 2.2 million. If they get the 30% fee reduction that they're asking for in their motion, and you land somewhere between $3 and $3.5 million. My problem with that is, and the reason why I said lower than that is because I think that their argument is ridiculous. I think their argument is trying to bill comprehensively for what was easily apportionment of just pure defense work. And they've already done it. Look, 2.2 million, purely defense. That's what they said. But you want to intertwine all this other stuff? I'm going to give you a portion of that. How about 9 causes of action? One of them was defamation. Divide 5.2 million by 9. You get $580,000. Add that to 2.2 million times 0.7, and you come up with something like 1.78 million. And so I'm getting my figures. What did Stu say his prediction was? Or does he have a prediction?
He said 7 figures, over 7 figures.
Yeah, but like what specifically?
I don't think he said. Stuart, what specifically? Can you tell us? He's still in the chat. He says HOL pretty much predicted everything that happened in the case, including the danger of 47.1. I mean, they were right about some of this stuff. Yeah.
They 100% were right about the 47.1.
Yeah.
The question, it was never a matter of they were wrong about 47.1. It was just a matter of what are we going to do with it? And even like this result, like hearing Fritz, well, Fritz didn't say that. You said this. That even in settling this case, the reason why they allowed them to pursue 47.1 fee shifting motion is because even if they want a trial, they're going to have it available to them anyway. And it's like, well, damn, that is quite the conundrum that 47.1 creates. And that is not something that, number one, when I first started talking about this case and hearing about 47.1, it's like, don't worry about that. Whatever, these facts, there's nothing to worry about. But not 3 to 4 months, yeah. That's kind of what I just said, right? Like if it was 3 to 4 months, yeah. That was my conservative estimate. My objective estimate was somewhere like 3.5, 3 to 4. I would agree with that. My optimistic opinion is 1.5 to 2. But there's definitely a basis for what Stu was saying, because if they just take the pure defensive work and give them half of the bucket 2 stuff, they're going to get 3.5 million.
I'm sticking with my 500,000.
Well, your 500,000.
I'm going to be a contrarian, just because
every attorney that's talked about it is disagreeing with you.
Judge Lyman, I think that a lot of people are negative on Judge Lyman, or and also you guys, I feel like you're educated estimates or whatever. But I'm just throwing this out there because I'm like Judge Lyman. I've seen him kind of deal with some of the bullshit that he, talks that Mike Gottlieb has put in front of him in hearings where he's like, that's not what the court said. And it comes back to bite them. And so like, I don't know if he's going to really appreciate some of the stuff that they did here where they weren't very clear or, didn't really put forth proof to back up their claims. So we'll see.
Matcha Latte says that makes me vomit if it's 3 to 4 million. It's reasonable. Look, if they get a 30% reduction, or 25% reduction, or 20%. There's going to be a reduction. The question is how much of a percentage are they going to get? And the reduction is going to be based on the hourly work, right? The hourly rates. Mm-hmm. And so that's a floating number, but they have pled 2.2 million in defensive costs. And so that's kind of a starting point. But then they have this 5.2 million in additional cost. If you just chop that in half, which is an easy way to divide it, in a non-incendiary way, in an appeal safe way to divide it, then that's how you get to the $3.5 million figure. If you chop that by 88%, which is my proposal based on logic, 1 cause of action out of 9, then you get to a $1.75 million figure, which I think would be fair and logical. But I can see an argument for both. Seeing that Judge Lyman just predicting that he's probably going to be more conservative than not, I can buy an award over 3 million. Not that I agree with it, but I could see him awarding that. I can.
Yeah.
But if I was the judge, I would award them 1.5. How about that?
A juicy Bruce, thank you for the $2. Says heart you, Lauren. Thank you. I love you back. And Ricardo Holt has, hi, Miss Lauren and Omar. Hi again, lovelies. Hey, thank you, Ricardo.
What's up, Ricardo?
All right. I want to go through this, which isn't too long, and then we'll probably call it a night after that. But this is Ellen's declaration attached to this, which I didn't get to go through earlier. I just went over the actual document. Let's see. We don't need to read this beginning stuff. Count 2 asserted defamation claim against Lively New York Times, alleging she provided false and defamatory statements. Times published it. We know all this stuff. Defamation was one of 9 causes. Okay. On March 20th, she moved to dismiss and for attorney's fees pursuant to 47.1. On June 9th, the court dismissed the Wayfarer complaint, including count 2 for defamation, and denied Ms. Lively's request for fees under 47.1. But we know she brought it back up in September because it was denied without prejudice. On January 14, 2026, in its separate state court action under New York's anti-SLAPP statute, the Times moved for summary judgment and sought $181,622.70 in attorney's fees in connection with the Wayfarer party's claims against it. A true and correct copy of the Times Memorandum of Law in support of that motion is attached as Exhibit 1 here too. And I guess what Blake's attorneys would say to that, or have said to that, is that her litigation was much more complex. Some of the stuff that she had to litigate in her action versus their action was intertwined, and also the New York Times, I believe, had a stay on discovery. Where the Lively action did not. So I don't agree that they should be paid fees for discovery related to her affirmative claims, but they think they should have fees related to everything. So I guess that would be their argument there as to why it's so inflated related to the New York Times ask.
Yeah, I mean, I could buy that. Again,
I mean, I don't buy it, but I assume that's what they're implying.
They're probably going to get a 30% reduction, similar to everything else. If 30 to 50% is going to be the reduction standard, then I could see them not getting 181,000, and maybe they get 120.
Yeah. And I don't know. That's the state court case. I haven't looked at that one in a minute. I know that they had asked for the court not to do anything while there was a pending possible appeal. Then, of course, they settled the case with Lively, and they're not going to appeal that.
I'm not up to speed on the New York on the New York Times case.
So the New York Times
in quite some time.
The New York Times will probably get their fees granted. I mean, they're
not going to get nothing. They're going to get something.
The New York Times?
They won't get zero. Yeah.
Yeah, no, the New York Times, I mean, because of the fair report privilege, I mean, I'm not sure there's much that they can do. It kind of seems like and I don't agree with this because I think that the New York Times did a lot that's not in line with ethical journalistic practice. However, based on the law and the fair report privilege, and you cannot punish a newspaper for reporting on a legal document, I think that the New York Times will probably get their fees paid. So,
the funny thing is, like you say that, like they did a lot of things that were unethical journalism. The law doesn't care, man. The law doesn't care. These laws exist because they have decided through whatever calculus that these laws as applied will determine what's fair and what's not. Yeah. And they're silent and they're blind to layperson opinions about what is ethical journalism or not. And it makes people really upset. But if you had it any other kind of way, it would just be like a less predictable. Hey, what happened to your hair? Jesus Christ, your hair got long.
Yeah, we've been over this. Wait, hold on. The back of it's like it's all the way down here now. I can almost. I can't really put it up yet, but I can almost get there.
You could do a man bun.
I know, right? Kat says, well, the law should care. The law should care. I agree the law should care. I'm just saying, like, there's at the time of stuff like this happening, and the law doesn't always, work the way that I would like it to. It doesn't. Unfortunately, it does not care.
God, I'll tell you what, man. I've been through a month. This is like the busiest time of my year. I've gone through multiple trials this month. And just today, we were going to start another one, and it got continued. And when I started my YouTube channel, one of the very first things, the very first premises that I have is like, good and evil doesn't matter in the law. It just doesn't. Everybody thinks that they're on the side of good. Mm-hmm. Everybody thinks that the opposing side is evil. Yep. And when you're an attorney on either side, there are people, half the courtroom is looking at you as if you're the evil one. Mm-hmm. And the other half is depending on you to effectuate justice. And I've given up trying to determine what for people good and evil is. I just you kind of land where you land. And so in this case, the New York Times, I mean, in the grand scheme of things, yeah, did they do some unethical things? I don't know, man. I'm not the judger of that. I will say this: Blake Lively, 100% frivolously pled sexual harassment against Justin Baldoni, based on the pleadings and the facts. And the result of that was her claims got dismissed, got motioned for summary judgment. If anything, in spite of the fact that it's an imperfect system, it gives me some semblance of faith in our justice system that we can recognize a bullshit complaint such as what Lively brought against Justin and have it thrown out completely. Now, the 47.1 is a wrinkle that didn't exist until 2023.
Right.
And so it's just another thing that we have to navigate around as we litigate these claims in the future.
Yeah.
But also in the future, because of this Baldoni case, I venture to guess that legal strategies pertaining to the defense of these kinds of claims will be mindful of 47.1 in the future, knowing the mechanics of how it works.
Yeah. Ricardo Holding for $2, $47.10 max award. Stay broke, flake. Right? I mean, I get where you're coming from. That would be a nice simple gesture.
Buy a dress for the Met Gala with $47.10. How about that? These nuts.
Yeah.
How about
that's
that?
That's your super chat there.
Oh, $2 from Juice Prusy. You, Omar. Oh, love you, Omar. I am bad with tech. I'm really bad with tech.
Well, at least you have your soundboard working, you know?
Man, every single show, man, just like the first 2 minutes is going to be like a wild card. There's something's going to go wrong. I just don't know what. Today I was muted for like the first 2 minutes. The other day in the last like 3 shows, I was on the wrong mic. So
she says D's nuts.
D's nuts from the back.
Okay.
There's gonna be consequences and repercussions.
Amen. Amen.
All right, let me move on here a little bit. Court granted Lively's fees on June 12th. Okay, I reviewed Ms. Lively's fee motion, blah, blah, blah. Without establishing any experience or expertise in allocating recoverable and non-recoverable attorney's fees under Section 47.1 or any statute, or providing a proper foundation for her opinions, including a showing of familiarity with the legal claims, facts, or issues relevant to this litigation, Ms. Kantner separated fees into 3 buckets. So this financial analyst they had sign off on this. Is that unusual to you?
Yes, insofar as that it wasn't an attorney, that it wasn't a billing fee expert. I think she was like an insurance person. I've personally never dealt with an insurance person opining in a billing motion that I've ever been involved in. And so is it unusual? Relatively. Is it unheard of? No, it's not unheard of. Does it make them subject to attacks? Absolutely it does.
Okay.
However, it gave them a really nice mechanism for separating these fees. Fees relating exclusively to the Wayfarer action, that would be bucket 1, like the defensive costs, right? Bucket 2, fees relating to exclusively to the Lively action, offensive cost. Offensive, meaning her complaint against the Wayfarer parties, right? And then fees relating to both Wayfarer and Lively, the intertwined version. And that's where we get involved with. And that's where they get themselves in trouble, in my opinion.
Gotcha. All right, Ms. Kantner then prepared spreadsheets of 2 categories of purportedly recoverable fees, 2.2 relating to the Wayfarer action and 5.2 in fees Ms. Kantner deemed intertwined, for a total fee request of $7.5 million. Neither Wilkie nor Manette provided billing invoices or receipts for the $539,514.01 in costs Ms. Lively seeks to recover. Instead, Ms. Kantner relied on spreadsheets provided by counsel to segregate allegedly recoverable fees from non-recoverable fees, and she determined which fees should be assigned to each category. This number, $540,000 about in costs, is that unusual? Like, is that like unusually high, or is that? Do you think that's normal?
I need to see the receipts. I mean, honestly, I've never started me personally, I've never billed a billing motion that didn't have the receipts. If I'm charging for fees, like for example, filing fees, printing fees, travel fees, whatever expenses, like those are expenses separate from hourly fees.
Yeah.
Those are easily trackable. easily accounted for. You just give them the receipts, and so it's indisputable. So if they're showing $540,000, I'm going to need that broken down with receipts. And if you can't, I'm looking at you sideways, because how hard is it to provide me those receipts? That should be like the least speculative of cost. Like, you paid something for something, tell me what it was. And so,
they didn't. I guess they didn't provide the receipts for whatever reason.
Very clearly, they didn't.
Ms. Kantner's summaries include descriptions that do not appear to have been taken verbatim from the billing statements, and she admits that she edited entries in the spreadsheets provided by Ms. Lively's counsel to exclude any portion of work descriptions that might disclose privileged or confidential information. Ms. Kantner, okay, so this right here, is that even a problem? I've seen, I think I saw something where they said she didn't have the experience to know whether or not she should do that, but at the same time, it's like, is that really, how serious is that?
So, are you asking about their descriptions being not verbatim from the billing statements?
Correct. So she she edited stuff to leave some stuff out, and some of it was like she put in like half sentences or put in like XX and like didn't really correct that.
Well, it's fine because it's easily rectifiable. I mean, if you send in redacted billing statements all the time. Like, for example, a version of a billing description might be subpoenaed or spoke to on the phone such and such a witness about specifically this specific issue that's internal in the case, that is part of a work product strategy that should never go to the other side. That's billed internally one way. The way that it gets out to is a trial prep, 3.5 hours or whatever. You know what I mean? So that would be an example of like a redacted billing statement. So usually when you're talking about these redacted billing statements, what you're really talking about is these vague billing statements that are subject to scrutiny. But there's a simple solution, like view the real internal billing records in camera, meaning just the judge. This is what we billed. So that way none of the privileged stuff gets out. And so it's not really a problem. It's just something that you could throw out the wall and maybe create some kind of an issue. Now, I don't think they're going to do all that. I mean, do they want to go in camera and just review the entire thing? Are they really all that concerned about it? It just depends. It's really up to them. It's up to them how much of a stink they want to make about it.
Okay. Let's see. Ms. Kantner also calculated reasonable expenses and costs at $540K without explaining how she calculated that amount, whether she was provided with vendor invoices, or how she determined what was necessary or reasonable, other than to state she applied the same principles used in the schedules that allegedly reflect reasonable and recoverable fees. Okay.
No, that's a reasonable grievance, because look, what were the expenses? Did you have to pay for deposition fees? Deposition fees, what, $1,500 for a half a day? Did you have to pay for travel expenses, go from California to New York? All right, bill the flights, bill the hotel expenses, whatever. But receipts for all of it, right? Was there, were there food costs? Was there printing costs, office supplies, all those things? All of those things are invoiceable. All of those things are receivable. So show me the receipts. If you're going to bill for fees, which are separate and apart from attorney hours that you would bill for just the work that you're producing on a case, you should be able to show the receipts. And it's a valid grievance for them to ask for cost and not supply the receipts.
Yeah. Okay, let's see. Ms. Kantner's schedules of fees and costs allegedly recoverable are extremely over-inclusive and deeply flawed. The summaries include work by 82 timekeepers, including 53 from Wilkie and 29 from Manat. Ms. Lively does not provide sufficient information to determine the reasonableness of the rates or hours worked. For instance, she provided biographical qualification, title, and billing rate information for only 11 timekeepers, leaving 71 unsupported. And I remember I don't remember if it was the beginning of this stream or your last one, said it was like excessive to maybe excessive to have biographical information for all 82 of them.
Well, there's just missing stuff about, okay, who billed what. I need their biographical information. I need their qualifications, give me their titles, who's billing for all these things. 11 timekeepers, leaving 71 timekeepers unsupported. Yeah, I don't know who these people are. Are these are they paralegals? Like, is this like Jocelyn at my firm? Is this like a entry level paralegal? Is it like the senior level paralegal? Is it like the 2L attorney? Is it like the 5th year attorney? I don't know, but it's a valid dispute, because look, if partner of the firm of a knots is billing at 2187, that's one thing, right? And you have a third-year associate doing the same kind of work. I guarantee you they ain't billing for 2187. And if they are 100%, that's excessive because their shit ain't worth 187. It's probably worth 300, 400, 500, whatever the going rate in New York is. But 2187, that's why you want the biographical information. And so this is my main discrepancies, my main complaint with the way that the Lively attorneys build this stuff is because they left so much of the work up to Judge Lyman. And if I'm Judge Lyman, if I was put in this position, it's like, yeah, who was billing for what? Because not all billers are created equal. I want to know. Then I'm going to bill you at the low end. I'm not going to bill at 2187. I'm going to award you attorney fees at $300 an hour. It's the only way to prevent inequity here.
And that seems super low. But,
I'm guessing for like a first-year associate or something.
Yeah.
Right?
So $300 an hour for these big law firms is like, well, are you dirt?
Some paralegals make
like the Van Zandt of lawyers that you're paying there.
Yeah, no, my paralegal makes $250 an hour.
Yeah,
and it's just the way. I'm just giving the extreme low end of the scale. If you don't apportion it for me, then I will apportion it for you, and you're not going to like how I do it.
Right.
But I'm not the judge, so there you go.
Yeah. Okay. So we're good there. Doesn't provide information to determine reasonableness. Blah blah blah. We got that part. The omission is material because those unsupported timekeepers include substantial billers such as Vincent Baggiati, I don't know, who billed 435.2 hours and $500,000. Jung Hyun, Monica Lee, who billed 307.4 hours and over $300,000, and Brent Danino, who was billed 306.4 hours and $188,000. Autumn Adams Jack. So you get the point here. There's a bunch of these guys who are billed.
It's reasonable to request biographical information of those folks. Absolutely. Exhibits
2A and B summarize the entries attributed to the 71 timekeepers for whom biographical information is not provided. Okay. Schedules B.1 and B.4 to Ms. Kantner's declaration purport to reflect work performed solely in the Wayfarer action. Those schedules identify 49 timekeepers who billed 2,069.9 hours and $2.2 million. As reflected in these exhibits, Ms. Lively provided no biographical qualification, title, or billing rate information for 38 of these timekeepers, although they billed 788.7 hours and about $700,000 there. In other words, even within the schedules that Ms. Lively characterizes as Wayfarer-only work, more than one-third of the hours and nearly one-third of the fees were billed by timekeepers for whom no supporting credentials, title, or rate justification was provided. Okay. Given the lack of foundational information, the breadth of fees and costs sought by Ms. Lively for the dismissal of a single cause of action pursuant to an early motion to dismiss, it is impracticable, if not impossible, to isolate or dissect each entry in Ms. Kantner's summaries. Okay. Under my direction and supervision, attorneys in my law firm converted the schedules attached to Ms. Kantner's declaration from PDF format into Excel after Ms. Lively's counsel failed to provide the Excel spreadsheets when requested. Using the Excel workbook our office created, I directed the attorneys to prepare spreadsheets showing examples from Ms. Kantner's summaries that demonstrate various flaws. Those spreadsheets are attached at 4 through 12, and I think I looked at those briefly earlier. I'm not going to pull them up right now, but they were prepared. Yeah, they were prepared by performing keyword searches and manually examining the entries. If a time entry contained the relevant keyword or descriptor, the entire time and dollar amount were counted in the totals. Okay, they're just kind of explaining their methodology here. I don't really need to look at that. Let's see. Due to deficiencies in the entries in Ms. Kantner's summaries, it was not possible to prepare a comprehensive listing of all entries that fall into the various categories. Thus, the exhibits are illustrative only. Exhibit 4 is entries for attorney internal meetings, calls, and conferences. Although Exhibit 4 is illustrative rather than exhaustive, the entries capture an estimated, it's like almost $900,000 there for internal communications. For instance, on May 29th, Ms. Klamaco recorded attend a litigation strategy meeting. On February 5th, Ms. Governsky recorded team strategy session and comm/legal call. On June 20th, Ms. Bender recorded attend partner call. And on June 16th, Ms. Connolly recorded partner strategy call. Ms. Hudson also repeatedly recorded entries vaguely described as legal strategy call or legal strategy meeting, including on June 2nd and June 6th. So is that like too vague?
I completely zoned out. What are we asking is vague?
So they're talking about the things they're billing for here: attend litigation strategy meeting or a partner strategy call. Do they have to be more
I don't have a
descriptive
problem with
than
those
that?
descriptions because look,
Okay.
when you're part of the reason why it's a pain in the ass to do these billing motions is because you have to redact so much, and you can't give away attorney work product, and so you're going to give these vague descriptions like a legal strategy call. It's a legal strategy call. What do you want to tell you? We're discussing whether or not Blake Lively perjured herself when she wrote the CRD. I'm not going to put all that in there. So legal strategy call. Kiss my ass. How about that?
I mean, I just wondered about that. I mean, I guess it's an argument they have to make, but at the same time, I feel like a lot of bills are probably written that way, you know? So
no, well, that's why I'm just
I
don't have a problem with that because I write billing motions like that.
Right.
They're vague on purpose because
I've seen one of yours. Yeah. So, yeah. Exhibit 4 demonstrates the lawyers spent an exorbitant amount of time conferring internally, illustrating the inefficiency caused by the numerous timekeepers. Okay. All right then. In addition, the descriptions of the time entries reflected in Exhibit 4 do not identify the issues discussed, the work performed, why multiple timekeepers were necessary, or whether the communications related to the defense of the defamation claim, collateral sanctions proceedings, or the broader consolidated litigation. All right. The billing records also reflect redundant or duplicative time, particularly where multiple senior attorneys billed to the same brief, motion, or strategy workstream on the same dates, or where the same timekeeper recorded serial entries for drafting, revising, reviewing, strategizing about, and further revising the same filing. Okay. All right, so they're giving an example here. Several timekeepers, including all of these people, billed for revising, finalizing, site checking, and strategizing regarding the same
People
rule.
are talking about Stewart as a pilot. I'm less concerned about his pilot status. I'm more concerned.
You want to
about
know his chess rating? Yeah. Okay.
He owes me a chess game. We need to play. I feel like we should do it for the channel. We should do it live. We should just, best out of 3. You know what? Best out of 7. Best out of 13. Just make it a straight up chess match.
I don't know, man. Maybe that's why he disappeared. He doesn't want to play chess with you.
30-minute time controls. We'll make it a 30-10 increment. We do it that, and then we do like a round 2 of like 5-minute games or 3-minute games or whatever. I'm in. I want to play Stewart, come on, man. We got to get it in. We got to get it in. We have to get it in.
email each other and set that up or something.
Lauren is so disinterested in my chess.
Oh no, he's here. Okay, he says let's do it. Okay,
so let's do it. I'm down.
No, I'm not disinterested. I just thought he left. So I just figured he was gone. I was like, I think he left. I think he got bored.
My fear is, I bet like Stewart's probably like 2,000 plus rated. He's probably like some chess genius. I'm like, man,
I have like a rating of at least
good day, or 1,600 on a good day.
I am rated at least 13. So fear me.
I know my wife's like, it's gonna be the swim meet all over again. Well, maybe
the swim meet all over again. Oh no, not the swim meet. That's what we should have done. We were supposed to do a second challenge and we couldn't figure it out. You said arm wrestling, which I thought that was a stupid idea. But
I thought it was a great idea. I can win that one. I think
we should have done chess.
I'll do chess.
Yeah, I wouldn't have won, but it would have been about as even as the swimming match was.
Well, I just want to point out for the swimming match, I was winning until I thought I was drowning, and then I pulled up for air.
Because that lasted about 10 yards.
I was winning for 10 yards.
10 of the 25 yards.
And then I swallowed water and I almost drowned.
You went into a different lane. It was all right, anyways. That's long over. It's long over. It's fine.
Oh,
all right, we're going to move on to the next thing here. Exhibit 5 shows an estimated 842 hours and $905,000 for sanctions related proceedings, including about $500,000, $530,000 for Rule 11 matters, almost $300,000 for spoliation. Okay, the spoliation was obviously when they settled her case, the spoliation.
Yeah.
Sanctions, that's one of those things where I'm like, why are you billing them for this? That's not related to their defamation claim at all. Okay. $50,000 for Rule 3.6 proceedings and $36,000 for other sanctions matters. I know that he already denied any monetary damages or anything like that in connection with the Rule 11 motion. So they write that here. The court declined to award fees. The court did not rule on the remaining motions. So with the Rule 11 motion, since the court already said no, and they're asking for it again, would the court possibly change their mind, or are they just going to stick with no on that?
No. I think that, well, it's not on Rule 11 grounds. Is it unless it's somehow meritorious on 47.1 grounds, it's still denied.
Yeah.
Judge Lemon has to decide that, though.
LVZ2 runs, as Stewart said from day one, he was worried about 47.1 and people came for him. Yeah,
no, he was right about 47. I'll say what. Here's a story about 47.1. Stewart, I forget how long he said he's been practicing. I think he said like something like over 20 years. He sniffed out 47.1 from the very onset, and he was very fearful of it. And he made it like this big thing, but everybody was so pissed off about, like, because the website had just come out. And it was like the very initial wave of like people being pissed off at Blake Lively for bullshit accusations. And so they didn't want to hear anything about she possibly has a meritorious argument under 47.1. I even disregarded 47.1 because of how ridiculous I felt the claims were. And I just never foresaw. Because, and to be fair to me and to other attorneys that have covered this case, I had not dealt with 47.1. It came about in 2023, and this is honestly the very first case that we've ever seen it be applied and learn the mechanics of how it works. And so we had no frame of reference. So I was largely viewing this case pre-47.1. And pre-47.1, Baldoni was completely fine. But Stewart bothered to read the statute and was like, holy shit, fee shifting? This is dangerous. This is dangerous. All she has to do is prevail. If he's not successful on the defamation claim, she prevails at, wait a minute. That's a wrinkle we never anticipated. And in his ultimate wisdom, and I know people came for him, but in his ultimate wisdom, he saw 47.1 was a problem. And that's why you pay lawyers the big bucks, because he foresaw that danger that ended up coming to fruition when everybody was stuck on their emotions of Blake Lively's case is bullshit. Hey, man, there's a reason why. There's a reason why you pay it for attorneys like Stewart, is all I'm saying. So we got to give Stewart his flowers on that one. On the 47.1, even if I was wrong, there was a certain point where I was like, wait a minute. I think Stewart is right. Holy shit. But for whatever reason, people didn't come for me the same way that they came for him. And I don't even know. I have no idea why that was. I'm just saying that. But then they kind of like fell out the face of the earth. I haven't seen them in like since like when were we at that thing in LA where we had that live thing with
I wasn't there for that. I was at the one in Phoenix with you.
Oh, we were at the Phoenix one.
So I wasn't at the LA one. Yeah. Yeah,
I was at another LA. That was the last time I've heard from Stewart. And then they just stopped covering the case. But yeah, I remember when everybody like kind of turned on them because they were angry because they were giving Ezra their flowers and talking about the dangers of 47.1. I think that was not justified. I think that they're owed a semblance of an apology from the general public. I'll go as far as
I'll say this, and this is something I've always thought, which is that even if somebody says something I don't like, it doesn't mean that I don't need to consider it or hear it. So I try to think of it that way, and I always they were never in any way negative towards me. They were always kind to me, even when they didn't agree with what I was saying. And you and I talked to them after the dismissal, and I remember disagreeing with like a lot of the sentiment, and we were all like civil with each other and friendly. And then I think that over time I've learned it is exceedingly difficult to say things that you believe firmly with you feel like you have a good reason to believe that, and that's how you really feel, and to have other people not want to hear it and then start to attack you for it. It takes a bigger person to kind of stand by your principles and say things that people maybe don't necessarily want to hear, as long as you're telling the truth. You know what I mean? I think then it'd be easy to like placate people and to say like, no, I think it'll be, XYZ, whatever that, people want to hear. And that'll get you, you'll get you more praise, but is it really how you feel? So say how you feel, and then people will stick around. The people that are supposed to stick around and who want to listen to you will, and the people who don't, they don't, they're not looking for you. They're not looking for you. They're looking for an affirmation on their opinions, which, honestly, I feel like based on my audience and the way I've covered this case, I give people that a lot of the time because that's how I truly feel, right? But sometimes that people's feelings and their audience don't align, and it's hard to stick by your guns in that situation. But I do admire the conviction and just being honest about that. So
I'll tell you what, not being a content creator and having people come for you in that kind of way, in a way that you're just completely not used to, takes a toll on your mental health.
Yeah, for sure.
And so if that was the reason why they stepped away, I completely get it, because I can't handle the negative press. Like when I get the negative press, I'll just straight up, I don't get much negative. But I also don't pay attention to some of the negative. But when I first started, I remember it affecting me a different kind of a way. It's just weird to have strangers just talk shit about you. They don't know anything about anything. They're just so. And then you try to no, wait, if only they would understand my side, and then you try to reason with them and they're still assholes. It's just it's a different kind of way of interacting with the world that if you're not used to it, I completely get the desire to step away from it. And so I hope that's not the way that I honestly hope that they just got really busy and they say, hey, we can't do this YouTube shit. Not right now. We got this big multi-million-dollar case going on.
Yeah, sure. Understandable. Yeah. Okay, let's try to get through. Let's do the rest of this here. This is talking about the replaced portions of the narrative with XX, which I think you and I just kind of discussed a little bit earlier on, where I was like, is that appropriate? If they're saying XX motion to dismiss, for example, XX interviews and articles, reviewing XX, media statements or whatever, that's not, to you think that's normal for billing, or is that a little weird?
No, it's normal.
Okay.
And like I said, there's an easy fix. If we're really that concerned about it, just review the internal records in camera. Problem solved.
Okay. Other entries refer to multiple motions to dismiss, further indicating that the claimed fees may include work unrelated to Ms. Lively's defense of the defamation claim. For example, on March 5th, Mr. Gottlieb recorded 1.5 hours for planning calls, discovering MTDs with legal team XX. And on March 12th, he recorded time for MTD drafts and related communications while redacting the identity of the party involved. Rule 11 entries likewise include work concerning unidentified parties. On June 9th, Mr. Nathan expressly recorded 1.5 hours to revise XX Rule 11 reply, in addition to 0.6 hours revising Ms. Lively's Rule 11 reply. On April 11th, Ms. Tofstein recorded 3.5 hours or 4,000 revising Rule 11 motion that included reviewing XX interviews and articles. This is just, we've already kind of gone over this stuff, so. They're saying not only are the entries containing XX unduly vague, but many other entries without redactions make it impossible to determine what work was performed, on whose behalf, in which action, or concerning which issue. Okay. Exhibit 7 identifies those entries. We kind of looked at that a little bit earlier, but let's see. Since this is all kind of relating back to the XX stuff, so we're going to skim through that. Let's see. Exhibit 8 shows Ms. Lively included time spent on matters other than her defense of the defamation claim. The entries include work on Ms. Lively's affirmative claims, such as opposing the motions for summary judgment and judgment on the pleadings, which was long after the Wayfarer countersuit was dismissed, and long after their deadline to amend their remaining claims had passed. So that's kind of one of those things where I'm like, why are you charging for this? Let's see, Wayfarer's answer to Ms. Lively's complaint, FIHA issues, discovery concerning Wayfarer's investigation of Ms. Lively's employment claims, and analysis of employment claims. All right. Okay, so here's another one I had a question about. Exhibits 8A through D. They demonstrate Ms. Kantner's summaries include work on the JonesWorks action, the New York Times motion to dismiss, and co-defendant Leslie Sloan's motion, practice, and discovery. Why is that included in Ms. Lively's fee motion? Is that...
Well, because that was their general premise, that their comprehensive work of the litigation should be applied through 47.1.
But why do they have to collect fees on Leslie Sloan's motion, practice, and discovery?
Well, that's obviously the Wayfarer party's argument. Like, what are we collecting fees on the Leslie Sloan stuff that has nothing to do with the defamation claim?
Leslie Sloan has a separate claim for fees, so why?
No,
why
I agree, and so it's that's why they're attacking it. And as you recall, like way back on June 30th, when they brought their initial fee motion, my big gripe with their motion was they're trying to include comprehensive litigation into 47.1, which I thought was bullshit. And they try to do this play on language. In the litigation, I remember it being in the litigation. I remember saying, yeah, the word "the" is the qualifier that requires that you go to the antecedent sentence that says the defense of the defamation being the litigation. Taken together means you're only recovering under 47.1 defense of the defamation, not for Leslie Sloan stuff, not for all this other stuff. And so that's why I'm assuming that they're bringing it up here in this declaration.
Okay. She also seeks fees for non-legal or business-oriented work, including advice concerning media communications, press coverage, social media reports, and client media appearances. Okay. Exhibit 9 identifies representative entries. Let's see. There's Ms. Hudson recorded an entry to strategize regarding client media appearances, to advise regarding legal issues related to a media statement. I mean, she should be billing her publicist for this shit, but I guess running it by her attorney is like something that they can do. So,
I mean, yeah, yes and no, but for me, the legal argument, it really was. I'm going to keep going back to that sentiment. 47.1 require. Okay, we have established you have earned fees under 47.1. The question of what does 47.1 covers? Don't be trying to put your comprehensive litigation bullshit in 47.1. If it's to be limited to defamation, and that's the reason why, in that bucket 2 of expenses, I wanted to divide it by 9. Just divide it by 9. I'm not giving you $5.2 million if you're not even willing to apportion that for me. If you're not going to do it, then I'm just going to divide by 9. 9 causes of action. One of them was defamation. I'll give you 1 out of 9. Or divide 5.2 million by 9. Land with whatever you land with. $580,000, I think it was. You can have the $2.2 million of pure defense damages reduced by 30% per the case that they cited, which was unpublished, by the way. But that's how I'm arriving at my figure, my prediction of like 1.75 million. That's where I'm getting my number. Now, that's exclusive to me. Judge Lyman is not going to do that probably. And if he does, I'll be so happy. But Stewart's prediction of 3.5 million is basically taking my prediction, 2.2 million, reducing by 30% and giving them 50% of the bucket 2 cost. That's how he's getting a 3.5 million. So if you want to extend that, the fee amount is probably going to land somewhere between 1.5 to 3.5 million. My prediction was 1.5 to 2.5 million, and my optimistic prediction was somewhere between 1.5 to under $2 million. That's how I'm getting my figures.
Yeah. Okay.
Hopefully you didn't glaze over on that, and you kind of get a feel for what I'm trying to say.
Yeah. No, I understand. I understand. It's okay.
All right.
I'm just so tired. I'm like, let me move on here.
Well, it's like over. Like, it's past
It's 1
midnight
o'clock.
for you. Jesus,
yeah, it's 1 o'clock here. Let's see. Miss Lively also seeks fees for non-legal or business-oriented work. We went through that. Let's see. Miss Lively also seeks fees for clerical or administrative work, including filing documents and counsel's internal document management system, iManage, indexing pleadings, organizing and updating trackers, calendaring, preparing binders and e-binders, distributing filings, managing service lists, and book reading, i.e. proofreading. Okay. That's annoying. I'm annoyed by that.
You're annoyed by the proofreading stuff?
I'm annoyed by all the clerical work that they're billing for.
Hey, the clerical work is the hardest part, man. Could I just explain?
No, I don't. I believe you. I'm just saying I'm annoyed by the fact that she's billing them for it because I think most of it didn't have anything to do with their defamation claim.
Here's what goes into billing a motion, right? I write the motion, and then I got to shepherdize. Well, I don't. Preferably, I would shepherdize, right? But like I'm verifying my sites, so I write the motion the way I want to write it, and then I do deeper research into the cases that I've listed, and then I have my assistant shepherdize the cases again, and try to break the motion, and then I have her proofread it, and then we rewrite it again, and then we go through the same exact process again, and then we stress test it. Against the best arguments of the opposing side. And then we come up with some kind of a tentative hypothetical outcome for the motion. And then we adjust our arguments one more time and then it's ready to file. That's how writing one motion might take conservatively like 11 hours.
Right.
That we probably are only going to bill you for like 6 hours for just because.
Ms. Lively also seeks attorney's fees for travel time untethered to any identified proceeding or event related to the defense of the defamation claim. So there's like 47 and a half hours and $55,000 in travel-related entries. For example, Ms. Hudson recorded 10 hours and $11,000 in a block that included travel from New York to Los Angeles, social media commentary, calls with unidentified persons, and multiple litigation work streams. On February 4th, Ms. Roser recorded 4.5 hours or $4,617 for travel from New York to LA. On May 30th, Ms. Hudson recorded 5.5 hours or $6,385.50 for travel from Washington, D.C. to Los Angeles. These entries do not identify a hearing, deposition, court-ordered appearance, compensable event, or other claim-specific purpose. And because several are block-billed with other tasks, they may obscure additional non-compensable travel time. So this stuff, some of this stuff, particularly the Washington, D.C. to L.A., my thought was maybe that was around the time that they had that hearing in L.A. Related to them trying to subpoena Brian Friedman's law firm. But that I don't believe that aligns with the same time. I could be wrong, but I'm pretty sure it doesn't. So I don't know what that would be for. Why were they billing for travel from D.C. to L.A.? That's strange.
I don't know, but if I was traveling from DC to LA to do anything related to the defense, I would bill for that too. It's a legitimate.
The thing is, I don't know that it sounds like like what was related to the defense though.
No, you're right, because absolutely, because as far as I know, didn't they have like the initial hearing on the 12B6 motion to dismiss, and there were some people there that were there remotely? I don't think anyone was there in person, were they?
Well, see, all of that would have happened in New York, though. They're traveling from D.C. to Los Angeles.
No, you're right. You're right to question it. And then it goes to their, like I said, their general premise. They're trying to fit comprehensive litigation into defense of defamation.
Right.
And that's what the Wayfarer parties are calling bullshit on.
Mm-hmm.
Justifiably so. So you're right to question it. Sure. In my opinion, if it's not related to the defense of defamation, I don't want it in the bill. Take it out, reduce it. We're here on the business of reducing. Get rid of that charge immediately.
Yeah. Man, they actually billed her for all this crap too. I kind of feel like y'all are buttholes. Lawyers are buttholes.
My wife
Lawyers are buttholes.
Y'all are buttholes.
I don't feel a lot of sympathy for Blake. So like, I don't feel bad for Blake if she actually pays for all this. But like, y'all are buttholes.
If I'm flying if I'm flying to some other city, if I'm flying to some other state to represent you, that's necessarily time taken away from my law firm. I'm only there for you. I'm not going there on vacation. So it's necessarily my time that I'm billing for. Oh,
you got a super chat here.
Well, I said I got a super chat. Could they be charging for being on Extra and Entertainment Tonight, both in LA? Yeah, they could.
What was the date on that? Can anyone get us the date on that?
They can legit bill for that.
Yep. Let's see.
I'm not saying that I would bill for that. I'm just saying that because Lauren just called me a butthole. I'm just saying that
I meant you people. You know what I mean? You people, attorneys. You're buttholes.
People, Lauren.
I've called you a lot worse for less.
Yes, you have.
Ms. Kantner's billing summaries show that Ms. Lively's counsel began billing work concerning Section 4701, fees, damages, and procedural mechanisms months before the current fee application. The motion to dismiss was in March 2025, included a request for fees, yet the records still do not reliably allocate compensable and non-compensable work. Later entries dated after the motion to dismiss was filed include work on fee motion strategy, appellate timing, damages options, legislative history, and preparation of motions for attorney's fees and damages under 47.1. These entries show that despite the foreseeable fee requests, the records continue to be block billed, redacted, and mixed across claims and proceedings in a way that prevents reliable apportionment. Thoughts on the non-English that I just read?
Oh, I completely zoned out. I was reading the comments.
Help!
Read it again.
Words hard.
Somebody called me a butthole and I was distracted.
Okay. So they're talking about the motions that she filed, the motion to dismiss. Then the request for fees. The records do not reliably allocate compensable and non-compensable work. Later entries dated after the MTD was filed include work on fee motion strategy, appellate timing, blah, blah, blah. And preparation for the 47-1 motion. These entries show that despite the foreseeable fee request, the records continue to be block billed, redacted, and mixed across claims.
Yeah, so the result of all of this is they're just saying, look, they didn't itemize out their bill. Fine, they didn't itemize out their bill. That
like
means
they should have done that if they knew they were going to ask for this. They should have item things out. Yeah.
In defense, I mean, I'm not defending anybody. I'm just saying, like, maybe the way to attack that would be to itemize it themselves. Like, if I was really itemizing this, these are reasonably attributed to defense. These are reasonably attributed to unextricable blah. Other litigation stuff that had nothing to do with the defense of defamation. Therefore, keep all of these out or whatever. They're not doing the job for Judge Lyman. That means Judge Lyman has to do it himself. That means he's going to rely on the case law and maybe even some arbitrary number. Like, for example, there's two, like you said, there was 3 buckets of fees. Remember, the first bucket of fees was purely defense related, and there was hourly rates. And then there's a case law. They're trying to argue that there should be a reduction in fees. The case that they cited, which was an unpublished case, reduced fees by or hourly rates by 30%. So cut 30% off of bucket 1. Bucket 2 was what the lively parties are claiming are inextricable litigation fees related to the defamation, but not exclusive to the defamation. But they didn't apportion that. And what this declaration is attempting to do is try to sort of argue that, but not doing the job really either. And so that means that Judge Lyman is going to pick some percentage to whittle down bucket 2. 50%, 30%, 11%, like I suggested, which is dividing it by 9. I don't know, but he's going to have to be the one to make that determination. And that bucket 2 reduction is going to largely weigh heaviest in what the final ultimate bill award is going to be. What do you think of that?
Sorry, I heard your weird sound.
I know you did. It's my daughter's favorite.
What was that? I got distracted by chat. Anyways, let's see. We're gonna move to the next one. The summaries provided for expenses show similar problems.
Or you will miss all that heavenly glory.
Okay. The summaries Ms. Kantner provided for expenses show similar problems. The Kantner Declaration, which purport to summarize the expenses, let's see, slightly seeks $540,000 in expenses across 7 categories. But the descriptions frequently fail to identify how the charges further the defense of the defamation claim rather than her affirmative claims. We've kind of covered that already as far as like the other monetary asks. Okay, let's see. I accidentally moved the page. I didn't mean to do that. Where was my page? Help me.
I sincerely think you're doing yourself a favor by scrolling further.
Yeah. The largest category, $374,450.14 in experts and consultants. Expenses includes a single $173,000 charge described only as GBX Holdings LLC, as well as generally described e-discovery services. But Ms. Kantner does not provide invoices, identify the work performed, or allocate those expenses to the defamation defense. Let's see. It's clear from Mr. Gottlieb's declaration that the approximately $173,000 in costs charged by GBX Holdings LLC were incurred for the purposes of assessing the impact to Ms. Lively's reputation, if any, from the Wayfarer action. Okay. Similarly, Ms. Kantner's summaries identified $173,000 in 47.1 related GBX charges and include invoice descriptions for new impressions, assembling a damages approach, 47.1 impressions collection, website and traffic analytics, calculation of impressions, figures, coding social media posts, reviewing social media posts for the use of the word defamation. That must have taken them a fuck long time, you know?
It totally
reviewing social media posts for the use of the words defamation. Do you know how many social media posts at that time were using the word defamation? And updating impression numbers. Those descriptions reflect damages and reputation impact work, not costs that are tied to defending the defamation claim itself.
Word.
Okay. Ms. Lively also seeks $134,000 in computer research expenses for Westlaw, Lexis, Bloomberg, Pacer, and similar charges. That's probably about the same amount I spent on Pacer.
You spent a shitload on Pacer.
I did, but in the end of the day, it helped me. It was an investment, like I was always getting to everything first, and that's how I built my channel a lot in the beginning. And then also I was able to use that as a receipt later on to show like, hello, why are you subpoenaing me for information I got off the government website? You know what I mean? So
it's brilliant.
Yeah. Okay. The $28,438.71 in travel expenses include charges for client meetings, strategy conference, a Lively v Wayfarer summit. Is that like a yoga retreat?
Ayahuasca. You know, I'm planning an ayahuasca trip for me and my wife.
I did not know that.
We're gonna go down to Peru and get fucked up.
That's cool.
And like enter the fifth dimension and learn intricate insights about the universe. That there's aliens in the ocean or whatever they say. I don't know. I don't know what we're gonna learn.
All right.
But it's a bucket list thing that we're planning is all.
Oh, so you're not going like next week? That's
no,
cool.
no. It's just something we want to do, and of course we got to find babysitters, and we're probably not going to do it for a long time.
Okay.
But it's on the list. Is all.
Co-counsel meetings that are not tied to a hearing or defense-specific events. We get local meals, public record searches, other charges such as lunches, background searches, and a transcript fee that do not show claim-specific necessity. They're allowed to bill for stuff like lunches and all that. Yeah. I mean
it's not. I personally would not. But
well, that's where I get like attorneys are buttholes thing. It's like I know a lot of attorneys who are not buttholes, right? But like every time I read about an attorney, it's a butthole. So
there's some attorneys that will charge you for sending a 30-second email. And there's some that'll just let that go. There's some that will charge you for text messages. There's some that'll charge you for their in and out bill for whatever holdover for trial. And then there's some that don't. I don't know. Me personally, I tend to put that stuff on the bill and leave it unbilled so they can see that I could have charged them for that, but I'm not doing it because I don't want to be a butthole. I just want you to know that this is impacting me somehow.
Yeah. And
out of the kindness of my heart, I've left it unbilled. Mushrooms are Peruvian marching powder. What's the difference?
There's not
one. What the hell is Peruvian marching powder? I want to try that.
I don't know.
Cocoa leaves? Isn't that just cocaine? Oh, I don't want no cocaine. I don't want that kind of stuff.
Who said
just give me the shrooms then.
Okay. Anyways. Move that back. We're almost done here, guys. I promise. All right. So they build for the special yoga retreat summit. They build for lunches and all that. Blah blah blah. That's what they're saying here. Taken together, the Cantner Declaration and supporting materials show that Ms. Lively's request depends on categories of work that are unsupported, unallocated, redacted, vague, clerical, collateral, or facially connected to matters other than the defense of the defamation claim. The problems are cumulative rather than isolated. Many entries combine multiple issues, including block billing, internal strategy communications, redactions, work for other parties or actions, media-related work, travel, and administrative tasks. The summaries do not permit a reliable determination of what amount was reasonably and necessarily incurred for the defense of the defamation claim. And that's it, pretty much.
So what is your prediction as a non-attorney, Lauren? What is the award going to be?
Yeah, no, $500K.
Man, that's an okay arbitrary number. We'll put it. You know what? It's like the price is right. $1.
No, $1. There's a big difference between $1 and $500,000. I say $500,000.
Get closest to the actual award without going over. You do the Price is Right bid. $1.
Dude, I just got a text from somebody. I just got a text from somebody. I won't say their name, just in case they don't want me to. I just got a text from somebody that says, "I clicked back into your live and you said butthole."
Oh, Lauren, do you even know what the Price is Right is? My wife's like, she don't know what the Price is Right is. Oh my God, you don't. Oh my God, I'm so.
I know what the Price is Right is. Yeah.
Well, what was the face for? You just made this face.
I'm looking at my phone, bro. All right,
oh, boy,
you have my attention. I know what the Price is Right is. It's a game show. You go on, you try to guess the retail price of items.
All right. Well, I'm going to stick with mine. 1.75 million. I'll just split the difference. 1.5 to 2.
Yeah.
I'll say 1.75. Stewart is probably going to be the correct one. He said 3.5. I think he said. Yeah, which I could see that being 3.5. That's
he probably has more of a bird's eye view than I do because he like stepped away, at a healthy time, and I just like, kept going and being frustrated by this for a year. So.
Oh, he saved himself a lot of mental anguish. I'll tell you that much.
Yeah. Amanda says, "Thanks for the $5. Will you do the exhibits too, please? I wish I could, but it is 1:20 in the morning here.
Yeah,
and I will die.
Also, another day, maybe tomorrow. I don't know.
But thank you, Amanda. I appreciate you for that, and I will try to look over that tomorrow. Yeah.
Nancy says under $1 million for Lyman's own safety.
$999,000.
Yeah, it's probably not going to be the $800,000 that the Wayfarer parties are saying.
No.
My very optimistic estimate for them, 1.75. The realistic number is probably going to be half of what they're looking for, 3.5 to 4 mil.
Mm-hmm.
That's what we're doing.
Look, I hate that, and I just need one more time to live in my cave of hope. So like $500,000. That's it.
All I'm going to say is, if I'm right, I am not going to be gracious about it. I am going to plaster it all over X. I'm going to do a show and say, I just want you all to know that I am the shit. I was the only one that predicted. I don't know what I'm going to do. We'll see. I'll do something.
Wait, oh my God. You're back on Twitter?
No, I had the X because of the Jingris thing. And so I've not posted on the X, but I will post on X. Just, I want you to know I'm the shit.
Well, at least somebody will be paying for something. I mean, they will be paying for you to make a social media post finally.
No, I am not on social media. But I will be on social media if I'm correct. How about that?
Okay, fair enough. All right, that's all I got in me for tonight, guys. I'm really tired.
That's all I got to. Yeah, I think it's bedtime. It's 10 o'clock. Wow, it's already 10:21.
Wow, gosh, it's 10:21. It must be so late for you.
No, it is, man, because I got to get up early and stuff.
Yeah, it's tomorrow here. So, all right, thanks everybody. I gotta appreciate it. Gotta appreciate it. I gotta go. I appreciate it. Don't forget to hit the like button for us. It helps us out a lot. And I will see you guys tomorrow when I am not falling asleep.
I love you, folks. You guys have a wonderful night. Bye-bye. Press the button, Lauren.
I'm pressing the button.